The word ambush landed in the London courtroom with theatrical force. It was delivered by Prince Harry's legal team as if it explained everything that followed. According to them, their client had been unfairly pushed into the witness box earlier than planned, blindsided by a maneuver designed to destabilize him. The accusation was sharp, dramatic, and instantly irresistible to headlines. But within hours, that claim began to unravel. A senior British criminal defense lawyer, someone with decades of courtroom experience and a resume that includes hundreds of major cases, publicly dismissed the idea outright. His assessment was blunt. The ambush narrative made no legal sense. In his view, what the public had just witnessed wasn't surprise or injustice, it was choreography. This matters because courtroom drama is not judged by emotion. It is judged by structure, preparation, and credibility. And when seasoned legal professionals weigh in, they don't do so casually. They do it because something feels off. To understand why, you have to understand how high-profile litigation actually works. In cases involving public figures, especially those with immense resources and global media attention, nothing is improvised. Witnesses do not stumble into testimony unprepared. They are drilled relentlessly. They rehearse not only answers, but posture, pacing, and emotional control. Mock cross-examinations are run repeatedly. Every conceivable question is anticipated. Every reaction is discussed. In that context, the idea that a single scheduling adjustment could derail an entire legal strategy strains credibility. Courtroom scheduling shifts happen constantly. Lawyers expect them. Judges permit them. Especially in complex civil cases, flexibility is routine. Claiming shock over a one-day change is not evidence of injustice, it is evidence of positioning. What unfolded that day looked less like confusion and more like conflict. Prince Harry appeared tense. His legal team protested loudly. Observers noted the intensity immediately. This was supposed to be a pivotal moment in his long-running battle against the British press, a moment designed to reinforce his role as the aggrieved party. Instead, it became something else entirely. From the start of cross-examination, the tone shifted. Harry did not behave like a witness responding to questions. He behaved like a participant in an argument. He challenged premises. He pushed back on phrasing. He expanded answers far beyond what was asked. At multiple points, the judge intervened to remind him of his role. That distinction is critical. In British civil proceedings, there is no jury. There is no group of citizens to persuade emotionally. There is one audience, the judge. And judges are trained to recognize performance. Emotional displays that might sway a jury can have the opposite effect in a bench trial. Observers described Harry as defensive, even combative. One legal analyst noted that he appeared to forget that he was there to provide evidence, not to prosecute his own case. The courtroom became less about articles under dispute and more about Harry's visible struggle to control the narrative. That struggle is not new. For 6 years, Prince Harry has pursued an aggressive campaign against British media outlets. Lawsuits have stacked on top of lawsuits. Appeals have followed defeats. The mission has expanded beyond specific stories into something broader and more personal. According to legal experts watching this case, the litigation no longer appears confined to questions of privacy or journalistic ethics. It has become existential. The lawyer who dismissed the ambush claim described what he sees as a permanent litigation mindset. In other words, a psychological state where conflict becomes identity. Every criticism is an attack. Every question is an affront. Every legal process becomes a battlefield. That mindset was visible in the witness box. Instead of calm, disciplined testimony, Harry responded as if every challenge required rebuttal. He interrupted opposing counsel. He disputed interpretations rather than addressing facts. The judge's repeated interventions were telling, not because intervention itself is unusual, but because of how often it was required. Experienced judges intervene when witnesses lose focus. They intervene when testimony drifts into advocacy. They intervene when proceedings risk becoming disorderly. And that is precisely what appeared to be happening. Yet the moment that dominated headlines was not legal at all. It was emotional. At a key point during questioning, Harry became visibly upset while referencing his wife. Media coverage exploded. Images circulated instantly. Commentators framed the moment as raw vulnerability, proof of harm, evidence of sincerity. There's just one problem. None of the articles at issue involved Meghan Markle. Every single publication cited in the lawsuit predates their relationship. They were written before Meghan entered Harry's life, before their engagement, before their marriage, before their departure from royal duties. Legally, her presence is irrelevant. So why did her name surface at such a pivotal moment? Legal professionals are not confused by this. They recognize the tactic immediately. Emotion in court is not discouraged. In fact, lawyers often advise clients not to suppress it. Displays of distress can humanize a witness. They can soften aggressive questioning. They can make opposing counsel appear cruel if pressure continues. But timing matters. The emotional moment occurred during some of the most difficult questioning of the day. It redirected attention away from uncomfortable factual issues and towards personal suffering. It shifted the frame from legal analysis to moral sympathy. Coincidence is possible, but courtroom veterans rarely believe in coincidence. The pattern became harder to ignore when the very next day, another witness represented by the same barrister also became emotional on the stand. Two high-profile testimonies, same legal team, same visible breakdowns. That doesn't prove manipulation, but it does suggest preparation. And preparation is not misconduct. It is expected. What becomes risky is when performance overshadows substance, especially in front of a judge known for skepticism. That skepticism may become decisive when the court addresses the most dangerous issue facing the case, the statute of limitations. Under UK law, privacy claims must be brought within 6 years of the claimant becoming aware they had grounds to sue. This is not based solely on publication dates. It hinges on knowledge, what the claimant knew or reasonably should have known, and when. This shifts the entire case. If it can be shown that Harry was aware of potential claims more than 6 years before filing, the case may collapse regardless of merit. Not because the articles were ethical, not because harm didn't occur, but because the law does not allow indefinite delay. Documents have emerged suggesting early legal consultations took place years before lawsuits were filed. Notes from those meetings may contradict later claims about awareness timelines. If so, credibility becomes the central issue. Legal analysts expect the defense to pursue this aggressively. It's a technical argument, but a devastating one. Courts enforce limitation periods strictly. Sympathy does not override statute. And credibility, once damaged, affects everything. Another pressure point looms: journalistic sources. Unlike the United States, source protection in the UK is not absolute. Courts can compel disclosure if it is deemed necessary for a fair outcome. In a case of this magnitude, involving royal claims and public interest, the balance may shift. Some sources may resist, others may not. Time changes loyalties. Relationships fade. Individuals who once protected confidentiality may feel differently years later. If sources come forward, voluntarily or under compulsion, the narrative could change dramatically. Harry has claimed that no one close to him would have leaked information, yet in other contexts, he has accused palace insiders of feeding stories to the press. Both cannot be true. If witnesses testify about who said what and when, the image of a singularly predatory press may give way to a far more complex picture, one involving cooperation, strategy, and selective disclosure. Meanwhile, Harry's conduct outside the courtroom has raised additional questions. During the trial, he was seen inside Parliament, an unusual move given the stakes of the proceedings. Observers immediately linked this to his ongoing campaign over security arrangements, a battle he has already lost in court. Despite that loss, he continues to press the issue politically. He has argued that reduced security places him at risk and criticized decisions made by the relevant authorities. Reports suggest this dispute has strained family relations, including during a period of serious illness for his father. Critics argue that the fixation on state-funded protection is less about safety and more about status. Wealthy individuals routinely arrange private security. What Harry appears to seek is recognition, confirmation that his position remains exceptional. This tension underlies much of the public response to his legal battles. He speaks frequently about empathy, inequality, and accountability, yet he has profited enormously by revealing private family matters while demanding absolute privacy for himself. He condemns intrusion while monetizing disclosure. That contradiction has become increasingly difficult to ignore. Even legal experts sympathetic to his claims note the cost. Litigation may deliver damages, it may produce favorable rulings, but it cannot repair relationships or restore trust.